Yes, thank you all for hanging in there for one of our last panels, and I know there's an important one coming up next. My name is Cathy Cramer, and I'm the CEO of Family Legal Care. You might have known us in the past as LIFT. We're the only organization in New York State dedicated solely to giving parents and caregivers the tools they need to represent themselves in family court on issues such as child support, custody and visitation, parentage, domestic violence, and guardianship. As I'm sure you're aware, 75% of the cases that come to family court are not child welfare or juvenile justice cases, which are, people get an attorney for. So most of the cases that come to family court people come without an attorney. We work with over 25,000 families every year. We work closely with the jurists and staff in family courts. We're all doing our very best with limited resources, understaffing, and tremendous caseloads. One of the things I think we very effectively do is keep people from coming to family court in the first place because we help them go get mediation or other things. But the family court was designed to be a place where you could get justice without an attorney. 80%, as we discussed, of litigants come without a lawyer. But the reality is that it is a complicated course. Legalese, high legal standards, procedures. Legal support is essential. The issues, as you know, are highly personal and emotional, having to do with kids and families' futures. And as we've discussed, the court mostly serves low-income families and people of color, and so reforming the family court is a racial justice and equity issue. We've talked about a number of the recommendations that we put in our longer testimony, but I want to start with one I haven't heard anything about today, which is the courts must prioritize child support. Child support is a poverty prevention tool that can help prevent other issues from ever reaching the family court, including domestic violence and child welfare cases. It's a way of trying to narrow the front door. 40% of all cases in family court involve child support, and yet these cases often take months, even years to resolve. Because child support involves money and there's a formula, people believe that child support is not a complicated legal matter, but that cannot be farther from the truth. As my colleague from Her Justice said, there are some cases where there's no conflict or contention. But in other cases where there is a lot of contention, litigants do not have a right to an attorney in child support unless they're facing imprisonment for non-payment. Pro se litigants are held to the same standard as lawyers and are expected to offer evidence, cross-examine witnesses, and to understand other court procedures like service, which is one of the hardest things anybody has to understand. So child support is not just about money, it's about housing, it's about health care, it's about food on the table. We talked about hiring more jurists and support staff. This has been a chronic problem for decades. COVID made it worse. Very high caseloads for all the jurists, very little support staff. Litigants end up waiting months. We talked about all that. We recently Family Legal Care came back into the courthouse to provide legal information to people who come to the courthouse, who, as we heard from the Judge Jolly, they can't give people legal information. So we do that in the busiest courthouses. There are a lot of new clerks that have been recently hired. The training is not excellent. People don't have experience, and they often give out the wrong information, and then that ends up with further delay. I was really glad to hear about the lack of standardized procedures across the family court, and that they must need to clarify the process, because someone comes in, they don't have access to us or even a clerk, they will never understand what they have to do to present evidence in court or understand the different procedures. And those cases get adjourned or dismissed based on technicalities. The family court needs to really improve its outdated technology. I, too, have heard about this website for years and years and years. We just upgraded our website. We offered to help the court because we've just been through this process of making it very client-friendly. Forms that are on the website need to be updated. One of our clients recently took a form from the website and was told by the jurist, this form is from the last century. She said, I got it off the website. So then we had to have another, adjournment. Another issue that I don't know if been raised today is that the court has limited access to UCMS, and organizations like ours do not have access to this case management system, which really limits our ability to give a clear understanding, for us to gain a clear understanding of the litigant's case history, and it would absolutely help with court efficiency if we knew what had gone on before. Our clients come in with us with shopping bags of papers. We spend half the time with our clients going through their papers. And then the last thing, or two more things. Last thing I want to say, 18B panel, we work closely with them. Many of our litigants, we want to, either need a full representation from an 18B lawyer. They need pay, they need a COLA, all the things that we've talked about today. But many people are so frustrated that they can't find their 18B attorney, so they call us up, and even if they had the attorney, they want us to support them with our much more immediate support. And then the virtual proceedings, I hate to think about them not being offered upstate, but one thing that we find with our clients, they do not have access to, it's the digital divide. So many of our clients will attend their virtual hearing getting public Wi-Fi at the subway station or walking down the street. That is not justice. And so I just hate to hear about our clients who, are 5 minutes late because of a subway problem, and the jurist dismisses the case or adjourns it, and 3 or 4 or 5 months later, they come back. They might have the same problem with teams that they had at the first case. We do not want to see technical difficulties impacting the outcomes of the cases. We love, particularly in child support, that virtual hearings are there, but not everyone can use it as effectively, so the court really has to upgrade their support. Strong families are essential to the welfare of our great state, and we think fixing these challenges, all the challenges we've talked about all day. Thank you so much.
Thank you so much.